This is the second part of Zahid's case. What is the legal effect of the phrases acquittal, discharge, DNAA, and DAA? Let's deal with acquittal. When a person is acquitted, it means that the prosecution has failed to prove the charge against him or her. He cannot be recharged for the same offense. That would offend the rule against double jeopardy. No person can be punished twice for the same offense. An acquittal can occur at 3 stages: during the prosecution case, at the end of the prosecution case, or at the end of the defense case. I'll explain. The timeline in a criminal case has several components. The first is the charge, the second is the prosecution case, and the third is the defense case. Suppose a crime has been committed. The police or the MACC or the customs officers investigate it. When investigators conclude that an accused should be charged, the prosecution will frame the charge. The accused is formally told to come before a court. The charge is read to the accused. He can either plead guilty or claim trial. Ahmad Zahid Hamidi claimed trial to his charges. If the accused pleads not guilty, that is to say, he claims trial, then a trial takes place. The prosecution at the trial will bring in evidence to show that the accused is guilty of the charge. At the end of the prosecution case, the public prosecutor will argue that it has established a prima facie case. What does prima facie case mean? It means that the judge must carry out a maximum evaluation exercise. This is still a very uncertain area of law. In practice, during a maximum evaluation, this is what the judge will do. The judge will study all of the prosecution evidence. He will ask himself these questions. If at the end of the prosecution case, suppose the accused remains silent, he calls no witnesses, he simply says, "I'm not guilty." If so, the judge asks himself this question: if this evidence before me is unrebutted, is it enough to convict the accused? That is what is meant by the maximum evaluation test. If after the maximum evaluation test there is not enough evidence to convict the accused, of course the judge must acquit the accused. If at the end of the maximum evaluation test there is enough evidence to prove the offense, the judge cannot convict the accused. He has to proceed to the second stage. This is called the defense case. At this point, the judge will say to the accused, "I now call you to enter your defense." Now, during the defense case, an accused has 3 choices. Each choice has legal consequences. First, the accused can remain silent, or he can testify as witness in his defense and call other witnesses. Suppose the accused chooses to remain silent. Suppose he calls no witnesses at all. If so, the judge has to carry on a second evaluation exercise. The judge has to ask himself, is the prosecution's evidence enough to convict the accused? Am I convinced beyond reasonable doubt of the guilt of the accused? If yes, he must convict. If not, he must acquit. The second option, the accused testifies. Here the accused has 2 choices. First, he can simply make a statement from the dock but refuse to subject himself to cross-examination. This is what Anwar Ibrahim did during one of his cases. Or the accused can testify and subject himself to cross-examination. If during the defense case there is enough material to convince the judge that the charges are groundless, the court can acquit him. Let us look at an example. Suppose A is charged for bribery. B is alleged to have bribed A. During A's defense case, A calls C, D, E, F, and G as witnesses. During their respective cross-examination, C and D separately but independently confirm that B tried to bribe A, but A refused the money. If by this time the evidence is all one way, at that point the judge can throw out the charge. He can straight away acquit the accused. He doesn't have to wait for E, F, and G. We now deal with what is known as DAA, or discharge amounting to an acquittal. Remember the example of A, B, C, and D above? Suppose at the end of D's evidence, the prosecutor has cold feet. He wants to cut and run. So the prosecutor tells the court, I really want to reconsider my charges against A. I might even withdraw the charges against him. Can you, my lord, give me a DNAA order? That is to say, discharge not amounting to acquittal. Now the defense counsel knows he now enjoys the advantage. He can refuse. He will say to the judge, I object. DNAA means they can recharge A. No, we do not want a DNAA. We want a DAA, a discharge and acquittal. So that is the DAA. Next, we will deal with what is called the DNAA. It has nothing to do with your chromosomes. It means discharge not amounting to acquittal. This means that the accused is only being discharged. He is not acquitted. He can be recharged for the same offense all over again. For example, when a trial is about to start, the prosecutor will call several important witnesses. It usually happens that one crucial witness may be absent on that day, or it could be that despite the prosecutor's best attempts, the witness cannot be traced. The witness may be indisposed or may be overseas. Now, unless it can be proven that the witness is deliberately being kept out of the way by interested parties, the court will not allow the prosecutor to waste the court's time. The accused will be discharged and acquitted. He'll be sent home. When the prosecutor informs the court and confirms that the crucial prosecution witness is available, the prosecution will restart the case. But a new charge will be framed against him. He will be recharged in court. He will be asked to plead to that charge. If he claims trial, that is to say, he says, I'm not guilty, the prosecutor can use all the evidence against the accused in the earlier case. The trial will continue to its conclusion. At the end of the trial, the court may either acquit the accused or find him guilty. There is no guarantee that the court will convict the accused. But in practice, a person under DNAA order is not always recharged. There is no guarantee of a second prosecution exercise. That is my experience. When prosecutors inform the court that they want a DNAA order against a politician and speak of restarting the case all over again, I get rather skeptical. I hope you found this video helpful. Goodbye.